Welcome to Law Talk Live. I'm your host, Gina Goosmann, CEO, founding and practicing attorney at Goosmann Law Firm. At Goosmann, we work alongside business owners, leaders, and innovators who are building something meaningful and want to protect it, grow it, and lead it with clarity. This series is all about bringing you real-world strategies, timely insight, and perspectives from professionals who are in it every day. You are now tuned in to Law Talk Live. Good afternoon, everyone, and I'm your host, Gina Goosmann, CEO and attorney at the Goosmann Law Firm. And today I am joined with an attorney. Her name is Ashley Krause. She's an attorney also at the Goosmann Law Firm. And I'm excited to have her with me. We are going to be talking about trusts, in particular, South Dakota trusts, and how they might be used as part of a relatively sophisticated estate planning tool and some asset protection strategy that can go along with those. And we're going to talk a little bit about what can be called a forever trust. And really, those are known as irrevocable trusts. And we're going to discuss how those are different from revocable trusts. I like to refer to them as a lockbox trust. And they can also make a lot of sense when you're looking for some stronger asset protection. But before we get into that and some of the technicalities and the differences, I really just wanted to welcome Ashley. Ashley, if you could give everybody a brief introduction of yourself and the kind of work that you do at Goosmann Law Firm.
Thank you, Gina. I'm so excited to be here. I'm an associate attorney licensed in Nebraska and South Dakota, and I primarily practice estate planning, so more transactional work. My background was in probate and real estate litigation, so I like to say that now I prevent the fires instead of putting them out.
Oh, very good. Very good. And Ashley, I have a little trouble hearing you. I don't know if you're able to get a little closer to your microphone or not, but that might help things out as far as that goes. Well, let's get into some of the different things that we do. I also practice in the trust and estates world in South Dakota, so I'm excited to have this dialogue with you because we work on a number of these cases together, and I think it'll be a great way for people to just listen in to what it is you're thinking about when we're trying to help individuals and families plan out their legacy. So in some plain English, if we can you kind of just talk about really why is a South Dakota trust special? Like, what's the deal with South Dakota?
So South Dakota is special because unlike many other states in the country, it has very, very flexible laws for trusts. One of the things that's unique about it is you can have a trust that lasts forever. Most other states do require that the trust end at a time certain, but not South Dakota. It also has a lot of very strong privacy laws, so it's very difficult for people to figure out what exactly you're doing, what assets you have. And finally, it's incredibly debtor friendly. It's very strong creditor protection laws, make it a very attractive jurisdiction, even for places that have strong protection laws already, like Texas and Florida. We get a lot of clients from there wanting to take advantage of South Dakota because it still meets that demand for protecting the trust assets.
You bet. And I think, in South Dakota, a long time ago, we recognized that there was an opportunity in the trust space to be able to have better laws than maybe any other state. And that was a strong economic advantage that the state wanted to create. And so we've had a really strong South Dakota governor's task force over the years, and the legislators have been really friendly to this area as well, really getting the legal community involved in making sure that South Dakota has favorable laws for people to want to do their planning in the state.
Absolutely. And South Dakota has more trust companies and more assets held in trust than any other state in our country by quite a lot.
Absolutely. I think there's trillions of dollars that flow through the state of South Dakota. And one of the ways I use to illustrate that to people is I will say, I think we have more trust companies on every corner than we do pharmacies. And when somebody's from like Texas or Florida or Arizona, they're always like, oh my gosh, that's really something, because they have a lot more pharmacies than they do trust companies on their corners. All right, so let's talk about what some people are calling a forever trust, or I think of it as a dynasty trust. Can you just explain that and what is the impact on that?
Sure. So the idea is that unlike a revocable trust, which is more of a probate avoidance tool, the South Dakota irrevocable trusts are set up as a tax and business succession planning tool. And it allows you to protect those assets, whether that be equity in your business that you've grown over the years or other investments that you've made for years and years and years. So because it can last forever, that means that as long as there's money in the trust, your business continues to grow, your investments continue to grow. Those assets can funnel down your descendants, so your children, grandchildren, great grandchildren.
And really, when do we start to think about an irrevocable trust for a client compared to a revocable trust? And I guess maybe we should just explain the difference between revocable and irrevocable before we get into that.
Definitely. So a revocable trust is essentially the extension of you during your lifetime. It uses your social security number as its tax ID. You're typically the trustee. You can make any changes you want to it. You can control it, do whatever you want as long as you're alive and you are competent. The irrevocable trust, on the other hand, it has a different goal, and so it has a lot of very different terms. Typically, we are trying to do some tax planning and creditor protection. So you may be the grantor or the creator of the trust, but you're not the trustee. You don't have direct access to the assets held in that trust. You also can't make direct changes to the trust. So we're kind of taking those assets, and as you said with the lockbox trust, we're kind of locking them away for our future generations.
Well, I think that was a great example, and really just the flexibility of, you change everything as you wish on a dime, or are we really tying these assets up in a more sophisticated structure? So when do we start to recommend an irrevocable trust for an individual or a family?
Sure. So usually once we are thinking that we're going to hit the federal estate tax exemption amount, currently it's $15 million per person or $30 million for a married couple. So I usually like to say 5 million is a good rule of thumb of assets that we want to start to fund it with. That gives you room for the assets to grow outside of your taxable estate in that lockbox trust. And as well, you're typically going to need a South Dakota trust company to serve as the trustee. And we want to make that worth your while. They do charge a fee for that. And typically they have a minimum amount. So $5 million, you're going to be able to use any trust company you want. As well, if we are thinking that there may be an extension of, or we may be hitting that threshold, we'll want to make sure that we're dealing with it before we hit that $15 million or $30 million to ensure that way, we are having that growth happen outside of the taxable estate.
And I think we were having some technical difficulties there with our microphone. So I just want to make sure everybody was clear that it's $15 million is the current level for the federal estate tax before it kicks in. And so if you're married and you take advantage of the portability provisions, that can double to 30 million. So really in those higher net worth estates where we're starting to look at irrevocable trust planning and putting assets into a lockbox. One of the other things that was noteworthy is that really it's whether or not you have enough assets you want to put into a lockbox, right? So usually we like to keep some assets outside of that. And so I think I heard you mention the $5 million. We're going to start to put $5 million into a lockbox. That's a point in which the South Dakota trust companies are going to get interested and want to take on that business. And where it can really start to make sense for a client to protect those assets. I think of, if you're worth, $30 million and you put 5 or 10 into a lockbox trust, maybe some high growth assets, that can really help you as those assets grow into the future and helping you with your estate tax liability too, because whatever you put into the lockbox, it's valued at the date you put it in there. And then it grows tax-free outside of that taxable estate of the individual. So a lot of big concepts there between gifting and taxes, and it can get really complicated, but we try and boil it down for our clients. Let's move on a little bit and talk about asset protection and why in particular can you get more asset protection, especially in South Dakota?
Sure. Well, part of that is because of South Dakota's laws in terms of protection from creditors. There is a certain degree of limitation that they will apply to a creditor. So even if they do get a judgment, it's very difficult to collect on that judgment just because of the protections that South Dakota has imposed for debtors. So really, that's the long and short of it. It's really a great place to do business. And so for that reason, we also tend to recommend that when we're funding these irrevocable South Dakota trusts, we fund it with a South Dakota LLC just to bake in that additional layer of protection that the state offers.
You bet. And I'm a big fan of South Dakota LLCs. In particular, they have a unique feature to them regarding a charging order. So really, ultimately, if somebody gets a judgment against an individual, they are going to be able to try and collect those on their judgment against their assets. And in South Dakota, the charging order against an LLC is limited to the distributions coming out of the LLC. They can't actually force you to liquidate the assets inside the company. And that's a pretty powerful thing compared to other states where they could make you liquidate your whole business. So I love that layering in of the South Dakota LLC and then having that company be what the essentially the South Dakota Irrevocable Trust owns.
Absolutely.
So let's talk about the creditor protection. Is it like all assets? Is there timing that matters regarding the creditor protection, or what are some of the nuances there, Ashley?
Yeah. So there's a couple things. The biggest one is, of course, child support, and that is across the country. Child support is its own animal. It is treated differently from debts because it's legally an obligation. So if you do have a child support obligation, they can invade the corpus of the trust to collect on that. But that's really the only major exception. Now, depending on what type of trust you have, there may be some time frames. So if we're talking about a domestic asset protection trust, which is one of the trusts that is more unique to South Dakota, you have a 2-year waiting period. So after you fund the trust, there's a 2-year waiting period where your creditors can raise claims and say that, make arguments you're trying to hide assets from them. After that, you're done. It is going to lock away those assets, and we have that creditor protection locked down. Similarly, with other types of irrevocable trusts in general, because we are irrevocably giving away the property to this trust, it's no longer in your taxable estate. And what makes this really great from the dynasty trust perspective is that once you have children, for instance, that are going to be beneficiaries under the trust. Let's say that the child gets into a divorce action, or maybe they get a personal injury judgment rendered against them, because their interest in that irrevocable trust is outside of their taxable estate. Those judgment creditors cannot attach to the corpus of the trust. They can't get into those assets. And then we have that that asset protection lockdown.
Well, I think a lot of things to go into that. And really one of the main triggers is you have to set these tools up before you really need them. If you're already facing a big lawsuit and the lawsuit's been filed, it's probably too late. So it's important to do this type of planning to preserve and protect what you've worked so hard to build before you really need it.
Absolutely. That's probably the biggest concern that people have is the timing. When should I do it? And really, once you realize that you've got this great business growth happening, you want to make sure that you're taking the actions necessary to protect it.
Definitely. So let's talk about who has to serve as a trustee and some of the different hats, because a trustee is not all the same. There's different kinds of trustees. So can you kind of break that down for us, Ashley?
Yeah, absolutely. So the administrative trustee is kind of what we think about as the person who calls the shots with the trust. They're the person who we're titling the assets in their name as the trustee of the trust. They're the person, the point of contact. Now, South Dakota does require that a South Dakota resident serve as a trustee of any trust there. So if you're going to take advantage of their laws, you got to take advantage of their businesses and use their people, which we're always happy to make those recommendations because there are some very, very talented trust officers here in South Dakota. Now, that being said, they're not the be all end all. So you can bake in different provisions to allow the grantor or the person creating the trust to still have some degree of control or non-binding influence over the trust and how it's managed. And those roles are usually the investment advisor, the investment trustee, and the distribution advisor or the distribution trustee. So the investment advisor trustee is a person who makes recommendations to that administrative trustee, to the trust company, on how they want the assets to be invested. And you can make this binding or non-binding depending on if you have an independent person serving in that role or not. So whether they are related or subordinate to the person who created the trust. The distribution trustee or the distribution advisor, on the other hand, very similar, except that they just make recommendations on distributions. So they can say, hey, my child is going to be going to law school. I need a distribution to pay for tuition. And then the administrative trustee will go in, get that money out, and make the distribution for the child. Because you think about it, the corporate trustee, they don't know the family, they don't necessarily know the ins and outs and the dynamics. So that distribution trustee, distribution advisor, they're going to be the advocate for the beneficiaries of the trust.
And I think that these different hats that I like to call them for trustees really are also somewhat unique to South Dakota with the fact that they created this administrative trustee role. A lot of families want to have their investment team that they've kept in place and worked closely with over the years. They want to keep their investment team. So they didn't necessarily want to change their trustee to just one individual or one person, or perhaps there's a lot of business interests involved, and that's where it can be helpful to have the investment trustee, or even sometimes we've put in place a committee that works with the investment trustee.
Yeah, definitely. Many of them, they say, why mess with success? Why can't we just have them continue to have the assets grow? And that really helps to make them feel secure and that they really are continuing to grow their dynasty.
And in particular, if they're a business owner, right? I think business owners, they've been successful growing that business and they don't want to tie up the future success there. And let's talk just briefly for a moment about how we're able to maybe peel off some of the interest and separate companies into voting and non-voting. Can you share some insight on that?
Yeah, so this is a really common question that we get from our clients where, oftentimes they'll hear that the IRS you can't have this retained interest. You can't have the beneficial interest of the assets. And so the way that we get around that is by splitting the equity into voting and non-voting interests. So we'll have the voting interest be maybe 1 or 2%, a very small amount, and that's the controlling side of the equity. Then the lion's share of the equity, that's the non-voting, we put that away into the lockbox trust. So the vast majority, 99% of that's going to grow outside of their taxable estate. But to the extent they need to make day-to-day decisions regarding the business, they can generally continue to do that by having that voting interest separated out from the irrevocable trust, placed into another LLC, or even into their own revocable trust. But that's just a way that we make sure that the IRS isn't going to step in and go ahead and include the equity into their taxable estate.
So I think that all of these concepts are really powerful. And one of the things I've noticed in working with clients is, they kind of get sometimes an all or nothing mindset, right? Oh my gosh, all of my assets are going to get tied up in this lockbox or irrevocable trust, or I'm going to lose power and control. And I think one of the things to consider is when you have a higher level of net worth, there are different tools that are used for different reasons. And I always let people know a revocable living trust is kind of the base of all plans. And then from there, as the assets grow, we layer in these different tools as they're needed. And it's really not an all or nothing approach. There's different reasons that we might put a percentage of a company, like we just talked about the voting and non-voting shares, into a lockbox trust. Certainly leaving assets outside of the irrevocable trust as well, and helping to guide clients through what should they put in these different types of tools and for what purposes. And I just think it's important for people that are listening to know that you don't have to just pick one tool. There's different reasons to use them. And I've heard recently, I was working with a financial advisor, and he said, it's like more money, more problems, right? And I don't know if it's more problems, but there are definitely different tools to use for different purposes. And it does increase, I think, the complexity of some of the planning, but there's a reason that we're able to help, navigate people through all those waters.
Yeah, absolutely. That's a great point too. I recently had a client who, one of his goals in utilizing an irrevocable trust was to separate out some of his higher liability investments from his lower risk investments. And so realizing that he could do that with these tools and bake it into his estate plan that he had in the state of his residence was huge for him. So I think as people are starting to realize, oh my gosh, we've got so many options out here and we can really customize it for them. It really helps encourage them to, develop their business and expand out from where they started, which is always really exciting to see.
It is. And I think that navigating that for those different individuals, it starts first with education. So I appreciate you coming on today and sharing some of this knowledge. Let's jump into really the different types of South Dakota trusts. And I know we've talked about a whole host of them, but I just really wanted to kind of outline some of the bigger bullet points, if you were to say that, regarding what kinds of trusts there are and the common types that we see. I let people know, we have all kinds of tools in our toolkit, and let's talk through some of the common types of South Dakota trusts.
Sure. I think the most commonly used one is what we call an intentionally defective grantor trust, or an IDGIT. And these are trusts in which the grantor, the person who makes it, they are taxed on the trust income. It passes through to them during their lifetime. So that's the intentionally defective part. But what we can do with it is it's very flexible as far as South Dakota trusts go. We can turn it into a spousal lifetime access trust where one spouse gives up their interest, but they can still have indirect access to the funds through their spouse. It gives the opportunity for, obviously, the creation of a dynasty trust with very specified terms for the children, grandchildren, and so forth that are going to be the beneficiaries there. So that would be probably our most basic vanilla lockbox trust there. The other very common one that's more unique to South Dakota is the domestic asset protection trust. And you can set this up in a few different ways, but generally the creator of the trust is actually going to be the beneficiary of the trust. So that's one way that it makes it unique. So they can still have access to it. But of course, you do have that 2-year waiting period before the creditor protection kind of jumps in. And you can also make it a hybrid where you have a third-party beneficiary, whether that's a spouse, a child, even a business partner. So you can really make it your own. We just kind of start out with those skeletons that South Dakota law provides us, and then we go in and highly customize it to what the client or the business owner really needs.
And I think even there, in some of our higher net worth planning that we do, we might use different trusts wrapped around different assets. Isn't that right?
Absolutely. So it just depends on really what we're funding it with. So when we have those very high risk assets, we may want to use a domestic asset protection trust for them, and then maybe a spousal lifetime access trust for less serious or less risky investments. We can also wrap it around those South Dakota LLCs, depending on what we are concerned about in terms of liability. Obviously, it's different depending on what industry the client is in. And so we really want to know exactly what it is they're doing and what the future looks like for that business so that we can adequately provide risk management.
And just to go back, I think we had some technical difficulty earlier, and I want to make sure it's really clear. How how much should someone consider funding into a South Dakota trust before it might be really worth it to go to the effort of putting this together?
Yeah, $5 million is generally a good rule of thumb. And that can be equity in your business. It can be real estate. It can be cryptocurrency, anything that we think is already valued at about $5 million, but is going to continue to grow. So we may have an estate tax problem later on, and we're trying to get ahead of that, making sure that as that 5 million balloons to 10, 15, 20 million, it happens outside of the taxable estate. Another reason for that too is because you are going to need a South Dakota trust company to serve as the administrative trustee. $5 million is a great benchmark. You're never going to be turned away. You will be able to work with any company you choose if you start out with that $5 million. So it also gives a lot of flexibility because we want to make sure that the client trusts their trust officer. Knowing that they can trust them with their dynasty is huge. And so we want them to feel like they can go to whoever they want to work with.
And we often refer to high growth assets being the ones that we want to look to first to put in a South Dakota irrevocable trust. What are we referring to when we talk about high growth assets?
So business equity is probably the most common one, and whether that's med spas, some of that can even be farming operations. Typically, that's what we're seeing with our primary funding. But in addition to business equity, we're seeing a lot more cryptocurrency. We're seeing real estate investments for multi-home properties. Those are becoming more common as well.
It can be a manufacturing company. It might be an online or a SaaS business. Really anything that they think is going to multiply and grow highly in the future.
Yeah, certainly. And, we also can, going back to that South Dakota LLC, depending on the asset that we're funding it with, particularly if it is something like real estate, or especially with crypto, where the law and the use of trust just hasn't really caught up with the technology yet. Using the South Dakota LLC to hold those assets and then have that be under the trust really helps create a layer of flexibility for the client as well.
So once again, why South Dakota over other states? What are your thoughts on that, Ashley?
Well, South Dakota just grants more flexibility and more protections when you get down to the bottom line. You don't have to worry about potentially having to pay off that judgment creditor if your high risk loan goes pear-shaped. Thanks to the charging order laws, it's very, very difficult to invade that LLC held by the irrevocable trust. And that's very unique to South Dakota. Even many other states, even with those strong creditor protection laws, they just don't have what South Dakota does. Additionally, if things change, because we're human, life happens. We don't have crystal balls as much as we really hope that we could. We may need to make changes to that trust. And one of the things that South Dakota does with its laws is it allows you to adjust the terms of that irrevocable trust agreement more easily than most other states. And so that's going to save the client time and money. And when you're an entrepreneur, it just doesn't get more valuable than that.
So when we talk about irrevocable, we do have some tools to make changes if we need to.
Yeah, and so that role is called the trust protector. Sometimes it's called the power holder, but basically that person is somebody other than the grantor and somebody other than the administrative trustee. So sometimes it can be a spouse or a family member or a business partner, and they have the ability to amend the trust agreement. So, let's say that a child is a beneficiary and they just had a child of their own that has special needs. We want to make sure that the special needs grandchild doesn't lose any government benefits. We can go in, use the trust protector powers, and amend the trust agreement to change the terms for that beneficiary, for instance. Or even if as simple as changing who our administrative trustee is, the trust protector has the ability to do that.
And the trust protector just can't be a beneficiary.
Exactly.
Or control really the assets inside of there. They have to be somewhat distant, don't they?
Correct. And that goes back to the IRS declaring whether somebody has a retained beneficial interest, which is tax law talk for, do you still have control over that property? Are you still doing stuff with it? Are you still getting the enjoyment of it? So that's why we want the trust protector to be an independent party. So oftentimes that business partner, they make a great trust protector.
You bet. And I always like to think of that, the uncle that you still trust, or that nephew that you think is really smart and sharp. And the trust protector might not know that you named them in that seat, especially if they're an alternate, maybe named the fourth or fifth in line.
Yeah, and that's something that we see quite a bit, where the client may say, well, I'm going to name this person as my successor, but I think I may change it later on down the line. Making sure that they understand that there is a degree of flexibility there, and that if they change their mind or things, change in the future, because we're always learning, growing, things just happen. They can do that. And many times you may have somebody named as a successor trust protector, and we take them out and they have no idea that ever happened.
Are there any big misconceptions about South Dakota Trust that we should discuss?
I think that the biggest misconception is that it functions the same way as a revocable trust. And I think that's where most people are confused, is that it's the same thing as whatever basic estate plan that they've put together in the state of their residence. And it's not. And going back to kind of what we discussed at the beginning, it's just a tool for a different purpose. So those revocable living trusts, the purpose is to avoid probate. Whereas the South Dakota Trust, the purpose is for sophisticated tax planning and to protect the family legacy for generations. The other thing too is, because so many people think of it similarly to the revocable trust, they don't recognize the funding necessary to put it in there. So they may say, well, I want to put my house in there for Medicaid purposes. But if you do that, it's going to be very, very difficult to sell that house later on. You're still going to have to be paying the South Dakota trustee an annual fee to maintain that trust. Technically, if you wanted to use that trust for Medicaid purposes and you put the house in there, you need to be renting your own house from the trust. So it's very complex. It's just not the same type of tool. But for those sophisticated business owners, for those entrepreneurs, it really is invaluable to protecting their legacy for future generations.
What is something someone should do if they've been listening to this and they're interested in doing some more advanced estate planning and working through perhaps setting up a South Dakota Trust? What's the first step? So
the first step is to think about what assets we can lock away that you don't need direct access to. Most entrepreneurs, they have multiple streams of income, and we want to identify what we can safely lock away that's going to not only continue to grow, but that they don't necessarily need or relying on direct access to. And in order to think about that, probably set up a consultation and reach out and contact a South Dakota attorney. Yes, I'm always happy to talk South Dakota Trust, and I love setting up consultations to learn about our clients and what kind of work they're doing and how we can protect their family. Absolutely. Well, with that, I'm going to transition over and we'll take a peek at some of the comments that have come in. I'm excited to see what we have. A lot of comments here today. So I think there have been a few questions, and one was about funding a trust. How do you typically counsel them on the use of voting versus non-voting equity interests? What factors tend to drive that decision, particularly when the goal is balancing succession planning, control, and estate tax considerations? Oh, good question, Abby. Yeah, this is a great question. So the biggest thing is to make sure that they understand that the client still has a certain level of control, but balancing that with that retained beneficial interest question. So very commonly, we will have a client that comes to us and they may own this company outright, and we're going to split the equity into voting and non-voting, have the non-voting go into that irrevocable trust. The voting is retained by the client. But to mitigate any claims of that beneficial interest, we'll just keep the board on that they've continued to use. I mean, that's really the easiest thing. So the internal structure of the company may look a little bit different just because of what we're doing funding wise, but ultimately the day-to-day should be the same. They're still going to have the ability to run the company, make decisions. They just can't be the only one to do it. So if you're a sole proprietorship and you're trying to do this stuff, we may need to make sure you've got some other people in there helping you out. But I would say, 99% of the time, it's just changing the structure on the back end. And we're keeping that control, the general day-to-day operations exactly the same as they always were.
And really, if we're putting the assets inside of a South Dakota LLC, it's like that LLC becomes a holding company for assets inside of it. And the investment trustee or investment committee could make decisions to sell different assets inside of the South Dakota LLC. And so it doesn't have to get directly involved in the actual operations of the company as well.
Absolutely.
Well, great. Well, thank you for those questions. Oh, we have another one. At what stage of life or wealth does it make sense to start thinking about a lockbox trust instead of waiting until an estate tax issue becomes urgent? Or is it solely based on the $5 million threshold? That's a great question. I think I'll start by saying I think every adult should have an estate plan, at least a basic will. And then for me, I often get to kind of the $1 million in net worth is where I start to recommend a revocable living trust. And then after that, you were talking about the $5 million threshold, and that does make a lot of sense at that point. Or if somebody becomes an investor or a part of a startup that they really anticipate is going to take off in a big way, that can be something that you want to look at early as well. Ashley, what are some of your thoughts?
Yeah. I think the other side of it is $5 million of high growth assets. So do think about that as well. So maybe you've got $10 million net worth total, and you've got some crypto investments that are really taking off. And now you're looking at it being around, 1-2 million, and you're thinking it's going to increase. I would definitely start thinking about doing some advanced planning at that point, because hopefully your investments are going to continue to grow, and identifying that growth early and then investing into that lockbox trust so that the growth can happen outside of your taxable estate is so much easier than waiting until you're hitting that $10-15 million mark. And now we're worried about having that estate tax problem, because federal estate tax, it's about 40%. So if you're at, you've got $20 million net worth and you didn't use any of your estate tax exemption during your lifetime, you're going to be taxed about 40% on that $5 million. So the government's going to take a pretty big bite out of it. And I think that as people are more educated on that problem, they're starting to come and do planning earlier so they can avoid it.
I always let people know, the government, it's easier for them to tax dead people than it is live people. And we always think about income tax every year. Everybody has to pay. April 15th rolls around. But really, the generational wealth transfer and the taxes that come into play, people don't pay enough attention to often until later in life, that they should think about earlier. We've seen a number of examples where people have higher growth assets and they should start to do the planning earlier. I've yet to have anybody come in that I think wasn't ready, wasn't ready for a plan. And we can help guide them to what kind of a plan they need. But for the most part, everybody needs a plan. It's just how sophisticated and complex does it need to be? We got another question here. While working through a divorce where the soon-to-be ex-spouse is the trustee or beneficiary, what should clients do during the pendency of the divorce to ensure their assets are protected? Oh, great question.
Okay, this is a really fun one. So I've had this happen once where we set up two spousal lifetime access trusts and the parties ended up being divorced. So the first thing is to look at the state that the divorce is happening in, because most states, they will automatically remove a ex-spouse as a beneficiary or a trustee from a estate plan that was created by the other spouse. So that's the first thing to look at. The second thing is to, if we're talking about an irrevocable trust or a revocable trust, typically the assets that were used to fund it, depending on who the beneficiary is, if it's somebody other than the children, the judge is going to look at possibly dividing that trust, ordering that it be terminated, and then you can set it up how you want once we figure out the marital assets, because we can trace it. If they're the trustee, generally they're going to be out, and then we want to use an exercise of trust protector powers to remove them as a trustee, trust protector, any sort of role in that trust, name somebody else to come into play. If they are the beneficiary of that trust, that's a little bit of a different scenario because they are still entitled to those assets. So if we're just strictly talking about a spousal lifetime access trust, that spouse is still entitled to receive the benefits under that trust. So that doesn't necessarily go away just because of the court order. It also depends too on the divorce decree and what is entered into that divorce decree, but typically they are going to be removed from the revocable trust, the will, not necessarily the irrevocable trust.
And I think this brings up a great point. Obviously, if somebody has set these tools up and then they're going to go through a divorce, they're probably going to want an estate planner on their team as they are preparing to go through the divorce. But we recently, I know, recommended a plan to a client, and they had multiple business interests. And part of the plan was for a SLAT, or a spousal lifetime access trust. And then part of it was just for a regular IDGIT, or intentionally defective grantor trust. And part of what they asked was, well, why do we need both? And I think that can be a little uncomfortable because, well, what if you get divorced? We don't want everything tied up in your SLAT. And so I think that making sure that you have some different flexibility with the different tools, again, it is important. And some families, obviously, we've got clients that, they've been married 44 years and really don't think they're going to get divorced. That's a different type of a plan. But a divorce is such a common thing in our society that it is something that we need to plan for. I often let people know I think it's their biggest risk to their assets, divorce, and then also later in life remarriages. All right, we've got one more. If someone already has a trust, what are some signs it may be outdated?
Well, I think the biggest thing that I always tell people to consider is any major life change. So marriage, divorce, birth of a child, adoption of a child, that's probably the first thing that you're going to want to look at. Trust laws, they do change from time to time, but really it's going to be about your needs, your family's needs. So as people grow up, their family's needs change. So maybe a trust that you set up when your child was 3 versus now that they're 23 and they've grown up, they've graduated college, their needs are going to be different. Maybe we want to consider letting them have a little access to those assets. One of the things I personally love to do in South Dakota trusts and irrevocable trusts is to allow the beneficiary child to serve as a co-trustee at a certain age with that trust company, so that they can kind of learn how to manage the assets and get a certain amount of maturity with understanding, or I'm sorry, distribution trustee, I should say, so that they can start to get some understanding of how to manage these assets and really continue to keep that dynasty trust going. So, think about where your family is now versus when they were younger, 10 years ago, 15 years ago, 20 years ago. The needs are going to change as we grow. And fortunately, we always include tools in our irrevocable trusts so that the trust can continue to grow with your family.
And I tend to think when we do an irrevocable trust for a family, we're usually communicating with them at least on an annual basis. And some of those with more advanced plans, they might be having quarterly meetings because they usually need ongoing legal guidance because of these sophisticated tools and the laws and how it all flows and functions. So once you set an irrevocable trust plan or an advanced plan up, it's not set it and forget it compared to a revocable living trust where you really probably can. Usually those last about 10 years before you need to take a look at it with an attorney or a major life event happens. So big difference between the type of planning with the irrevocable versus the revocable. Well, I wanted to thank you again, Ashley, for your time today and joining me and breaking down the ways that business owners and families and individuals can understand some of the advanced planning and South Dakota trust advantages that we're able to work with, because these are really powerful tools. And they're not automatic, simple, or just straightforward, and they're not right for everyone. But for those clients that they are, I think it's really exciting opportunity to take advantage of these different tools and structures and select these different types of tools and make sure you have the right timing and tax considerations and advisors coordinated. And we'd love to help guide people through that whole entire process. So thank you again for coming on, and thank you for joining us on Law Talk Live and for all the engagement today.
Thank you so much, Gina. I really enjoyed my time here.
At Goosmann Law Firm, we believe the right conversations at the right time can change the trajectory of a business, a decision, or even a legacy. You can connect with us here on LinkedIn, follow along for future sessions, or visit GoosmannLaw.com for more information and additional resources. Thanks for joining us today, and we'll see you next time.